Okay, sorry about that, ladies and gentlemen. I think there would be there's a bit of a hiccup in your recording. That's because I started coughing, so I wanted to spare you that. Anyway, so we continue with the slide on financial distress. Um, the last alternative is if it's otherwise just and equitable for financial reasons. Now, it wasn't clear to anybody what this meant because surely just and equitable for financial reasons would have something to do with the financial situation of the company, and that's already covered by financial distress, commercial or factor insolvency. Um, so that was largely ignored, but in a Tire Corporation Cape Town case, which is in your textbook, you will see that the court here, first of all, also held, as was already held in the Oakden Square case, that a company that is already insolvent does qualify for business rescue under the right circumstances. So the fact that it's already insolvent does not disqualify it automatically. And then the court, for some reason, the court was a little bit uncertain about that. And then the judge added, but in case I am wrong, I would say that it is otherwise just and equitable for financial reasons. So it's sort of a backdoor, but it doesn't seem necessary to have that provision. So we're still not 100% sure of what they meant by that. Right. Now, the next slide, um, which deals with the second requirement. And this is actually the most important requirement of the two, because if there is no reasonable prospect of a rescue, then the why commence business rescue. So, as you have seen, the reasonable, there's no definition of a prospect of rescue. The act has been criticized for that, but I don't think that was really a valid criticism because prospect of rescue will very much depend on the facts of each case. So it's very difficult to define it, but it obviously means that there must be a reasonable prospect of achieving one of the two goals of business rescue. Now, I've already mentioned to you that there are that the Oakden Square case, in that case, the Supreme Court of Appeal said that the two alternative goals are on equal footing. In other words, you don't have to first actually try to rescue the company, and if that doesn't work, then you go for the second goal. You can actually from the very start go for the second goal, which is a better return for creditors. Now, that really is such a vague requirement because it's a guesstimate in the application to say what you think the creditors will get in business rescue. Usually they get far less. And in the Deloitte restructuring survey of 2023, they actually say the challenge is that every rescue plan I've ever seen is a soft liquidation. Business rescue needs more turnaround consultants. That was a business banker. So what is happening is that business rescue is being abused by people who know that there isn't a real possibility or prospect of a rescue in the sense of returning the company to solvency. They use it as a sort of a liquidation, but without all the requirements and formalities of liquidation and without the supervision that you will find in liquidation, because a liquidation is overseen by the master of the high court, and there are meetings and formal accounts and um, far more safety nets that you can have a section 417 examination. All these things are not available in business rescue. So the business rescue practitioner has more or less total freedom of movement. Creditors have a vote eventually on the rescue plan, but we have seen that creditors sometimes because of ignorance or because it's their own personal advantages. They will vote for plans that are totally impossible. And the CIPC does not get a copy of the rescue plan. The Act does not require a business rescue practitioner or the company to file the business rescue plan with the CIPC. So the CIPC has no idea of what is happening in the business rescue and what the business rescue practitioner is planning to do. So that has also led to a lot of abuse, because in most cases, the vast majority of cases, there is no intention or actually a possibility of rescuing the company itself, so that it's only for the second goal. Now, because of that, you will see that originally some courts were not very happy about this, and they actually said that you cannot base your application for a business rescue on and then say right at the beginning, I know this company cannot be rescued, but it'll give a better advantage to creditors. These courts held that you should have at least a possibility of rescue. You must say, I will try to rescue on these grounds, and if that doesn't work, then I will go for an advantage, to better advantage for or dividend to creditors. You cannot start a business rescue procedure by admitting that there's no real possibility of a proper rescue. But of course, that is not what the Act says, and they have been criticized for that, and that is not what the courts are saying anymore, especially after the Supreme Court of Appeal in the Oakland Square case said that you mustn't be too strict about it. Now, the proof of a reasonable prospect, as I said, it's not defined, so you cannot really measure it against the definition. It depends on the circumstances. And there has been quite a bit of a difference of opinion on what would constitute a reasonable prospect. The Southern Palace case actually started this debate, because the judge in that case said that if you apply for a business rescue order, I would expect you to tell me, first of all, what went wrong. Secondly, why did it go wrong? Thirdly, how are you going to fix it? And where is the money going to come from to fix that problem? Unfortunately, the judge used the words, you must have a rescue plan. I think he said a rescue plan. That was immediately criticized, as if he had required a formal business rescue plan. And of course, that's the job of the business rescue practitioner. I'm sure that's not what he meant. And actually, although this has been criticized as being too strict and setting the bar too high, etc., you find these requirements in different words in various other later judgments, where the court, for instance, would say, you cannot come with vague allegations that there will be a plan. You cannot just say there is a possibility, a reasonable prospect that there will be a plan that could possibly be approved. You must have at least some idea of how you're going to rescue this company. What are you going to do? How are you going to do it? In others, the application was refused because there was no sign that there would be any finances or capital available for this rescue. So there again, you have that requirement. So I don't think that Southern Palace was all that wrong. It's just that perhaps the judge used the wrong word, but basically it was a sensible requirement. So there cannot be, as you will see, that the court in Oakland Square said that a mere speculative suggestion is not enough. And vague statements, there must be something concrete to show that there is a real prospect of a rescue. In Normandy Restaurants case also, the court said we require more than a mere prima facie case before we will allow a business rescue to commence. Now, the other problem that we have is that should be the attitude or the approach of the court when an application for business rescue is contested by uh, uh, or opposed by major creditors who say that they do not believe that business rescue is possible in any event, and they will vote against any plan that a business rescue practitioner may come up with because it is clear to them that there cannot be a plan that would work. Should the court take note of that or not? Now, in Oakden, the court said you cannot ignore the fact that if a major creditor states, a creditor that has enough votes to actually have any plan rejected, if such a creditor says, I will vote against any plan, and the attitude of this creditor is not unreasonable, then you cannot ignore it. And then you have to find that there is no reasonable prospect of a rescue, because you cannot have a rescue without a plan that has been approved by creditors. Not all the courts agreed with that. Some of them said, well, it's unreasonable to say that right at the beginning. You have to wait until you've seen the plan, and only then can you decide whether you should vote for or against it. In the Shoprite Checkers case, which is also mentioned in your textbook, the court said there could not be a reasonable prospect of rescuing if the major creditor indicates that it would vote against any plan, and you cannot expect a creditor to vote against or vote in favor of a plan that would not be in his interest. However, you will see later on when we get to the setting aside of votes against the plan that the courts have not been very consistent here, and it seems as though this is not such a clear-cut situation. There is a recent Western Cape decision, which I won't bore you with. You don't need to know the case, but in this case, the company was already in liquidation, and a major creditor, which is a bank, made it clear that it would vote against any plan. And here the court again quite sensibly said, well, then there cannot be a prospect of a rescue. It's clear that the company is already in serious financial trouble. It's been in liquidation for some time, and most of the employees, or the most important employees, have already left the company. So drifted away, as the court put it. So it's clear that this attitude or this approach of the major creditor is not unreasonable, and for that reason the court actually refused the application. Now, the question of when does business rescue commence? In terms of section 132.1, it commences when the company files the resolution to commence business rescue with the CIPC. But as I have already said, the CIPC's approach or policy is it doesn't automatically start with filing. You have to wait until you get an acknowledgement of receipt from us to say, we have received your resolution, the filing of your resolution. All the documents we require were attached or enclosed, and we are happy that all the requirements or formalities have been met, and then that's when your business rescue commences. So you cannot just assume that once you filed the resolution, now the company is in business rescue. The acknowledgement is supposed to come back to you the same day or within 24 hours or something, but at least you have to wait for that. That is what their view is. Also, when the company applies to court to file a resolution in terms of section 125, less than 3 months after the resolution has lapsed. As I said to you, you can apply to court, but that doesn't happen anymore because of the Panama versus Nel case, where the court said, even if your resolution lapses, it doesn't mean your business rescue has terminated. And if nobody applies for the resolution to be set aside, you carry on with your resolution that has lapsed, that is a nullity. So most companies won't bother with such an application unless you are fairly certain that some or other affected person, usually a creditor, is going to apply for this resolution to be set aside because the more formalities were not complied with. And so if you want to prevent that from happening, and you don't want that uncertainty to hang over your head, then you would apply to court to file a new resolution. You get that because it's an ex parte urgent application. You get your order within 24 hours, and then you can immediately file your resolution. But in any case, the company is in fact already in business rescue again the moment it applies to court for that resolution, for approval of a new resolution, or approval or consent to file a new resolution. Then when an affected person applies to court for an order placing the company under supervision. Now, under supervision is just an alternative way of saying it's in business rescue. Now, this does not make sense, because that means if you apply to court, you at that point, you don't know if the business rescue order is going to be given or not. There's no business rescue practitioner to start the process, because that only happens when the court orders the commencement of business rescue. How can the process start without a business rescue practitioner? But once business rescue has commenced, the directors are no longer entitled to act without the authority of the business rescue practitioner. But there isn't one. Also, you will see in other sections of the Act, it talks about an application to court for an order placing the company in business rescue. So even the Act in other sections talks about the order to place a company in. It's an application for an order to place the company in business rescue. So I think we may safely assume this is just another example of very bad drafting, and that actual commencement is of the business rescue proceedings will only be once the court has issued that order commencing business rescue. And then also, when a court makes an order placing a company under supervision during the course of liquidation proceedings or proceedings to enforce any security against the company, the court actually has the power to order the commencement of business rescue, even though there is no application for business rescue before the court. So it could be an application for liquidation, it could be an application to enforce security, and then the court may decide that this company actually has a reasonable prospect of rescue, and then the court may, of its own accord, in other words, miro motu, can order commencement of business rescue, although this was not actually asked of the court.